Hello, my name is Harold Scott Roth, and I'll be your host here today at the Hudson Institute, the Center for the Economics of the Internet. We're very fortunate today to have with us Caleb Kruckenberg, head of litigation at the Center for Individual Rights. Today, Mr. Kruckenberg will be discussing a couple of recent Supreme Court cases, one that has gotten a lot of attention, Loper, and one that hasn't gotten nearly as much attention in my view, which is Corner Post. I think they both have substantial implications for the way in which regulation is done in the United States, and I think that has a lot of potential effects on regulation of the internet going forward. Mr. Kruckenberg has an incredible resume. Let me just read parts of it for you. Innovation and creativity and determination were the foundation of America's greatest successes, but those same traits are the ones most feared by self-sustaining government bureaucracies. It's no coincidence that Caleb regularly represents entrepreneurs, outspoken critics of entrenched power, and those simply unwilling to compromise their core values in the face of oppression. Caleb previously worked as a prosecutor, public defender, a lobbyist for a national advocacy organization, most recently a litigator protecting the separation of powers at both the Pacific Legal Foundation and the New Civil Liberties Alliance. He has won major victories against numerous federal agencies, including the U.S. Department of Justice, the Department of Labor, the Bureau of Alcohol, Tobacco, and Firearms, and the Securities and Exchange Commission. I don't see the Federal Communications in there yet, but one day I suspect that'll be the case. He is also proud to have sued every U.S. Attorney General, 8 so far, since he has been litigating against the government on behalf of liberty-minded clients. Caleb has also argued more than 20 times in the U.S. Court of Appeals, winning cases in 8 of the 12 regional circuit courts. Welcome to the Hudson Institute.
Thank you.
I understand you have some prepared remarks.
Yes. So good morning, and thank you again for having me here to talk about one of the biggest, most notorious Supreme Court cases of the last term of many, but also one that I think was overlooked somewhat. But I want to back up a little bit and start with some first principles and talk about separation of powers, which is something that I care very much about and I've litigated for a number of years in the public interest. But when I talk about the separation of powers, that's kind of a shorthand way of complaining about who gets to make decisions. And the unique design of our Constitution means that all of the relevant stakeholders, President, Congress, the judiciary, and the several states are always fighting over who gets to make the right decisions. And it's kind of like a game of rock, paper, scissors because it works because there's no right answer for every task. You always have a chance of losing and you have a chance of winning. Unfortunately, the fourth branch of government, contemporary administrative agencies, have created a crisis in that design. And that's something that's been going on for at least the last 50 years because agencies have something of an unfair advantage over the traditional branches of government. Congress, fearing repercussions from voters, have overly relied on assigning important decisions to administrative agencies. And courts have traditionally been hands-off. Much of the real work of governance has been handled by political appointees of both parties, often seesawing between administrations. In Loper Bright versus Raimondo from the Supreme Court last year, the court punctuated a recent revolution in administrative law by overruling its Chevron versus Natural Resources Defense Council precedent dealing with deference to administrative agencies. And that decision has really led the rise of the fourth branch and the, in my view, improper delegation to administrative agencies of substantive decisions and important decisions. While Chevron purported to be a very limited decision that really was not controversial at the time, as we all know, Chevron deference has become the beast of administrative law. When Loper Bright finally overruled that decision, I think pundits on both sides got very excited. Some people claimed that it was the end of the government as we know it. Others praised the return to the end of administrative agencies. Respectfully, I think they're both wrong, but it is obviously an important decision, particularly when read together with another case decided on the last day of this term, Corner Post Incorporated versus Board of Governors of the Federal Reserve System, which is a great case name. And that case talked about the somewhat dry and seemingly unimportant question of when a claim accrues under the Administrative Procedure Act. But what is important about that decision is that Corner Post held that a claim accrues and thus the statute of limitations begins to run and a litigant can challenge an administrative regulation whenever they're injured, no matter when a rule was issued. Now, reading Loper Bright and Corner Post together suggests that something big might be happening below the surface. In Loper Bright, the Chief Justice's majority opinion included a very notable caveat, where he said, to sort of guard against the fears of destabilization and what appeared to be a revolution in the decision, he said, this decision, quote, does not call into question prior cases that relied on the Chevron framework. Of course, if the statute of limitations for old regulations that have been issued years in the past is now open, I have some doubts about the complete accuracy of that statement. Before we get there, I want to take a step back and just start a little bit about administrative law principles in general. The basic premise of federal administrative agencies, as most first-year law students learn, is that agencies are supposed to be filling gaps. They have gap-filling authority in congressional statutes. And the idea is somewhat simple. It says that Congress cannot possibly legislate on everything and can't anticipate every scenario. And there are certain circumstances, particularly in complex statutory schemes, when we want someone else, an administrative agency, to fill the gap. An easy example is in the Clean Air Act. The Clean Air Act sets very complicated rules for emission standards, and one of its many, many provisions sets emission limits for, quote, stationary sources of pollution. Now, it is not immediately clear to me, and it was not immediately clear to courts for years, what exactly a stationary source of pollution is. Does this mean an entire plant? Does this mean little parts of a plant? And this is where we get Chevron versus the National Resources Defense Council. Now, that case dealt with an EPA that, in the NRDC's view, was not taking a strong enough stance against pollution and was taking a too limited role of its regulatory authority as a federal agency. And the EPA had said, we will consider a stationary source to be a whole plant, meaning essentially that certain industrial plants could make up for polluting in some ways by reducing emissions in other ways. The NRDC thought this was improper. They thought this was unreasonable. This went to the Supreme Court, and in a very uncontroversial decision, in very sort of plain language, Justice Stevens said, in a situation like this, as long as Congress has explicitly left a gap for an agency to fill, as long as the statute is unclear, Congress has not answered this question, quote, such legislative regulations are given controlling weight, unless they are arbitrary, capricious, or manifestly contrary to the statute. This sort of came from a long line of decisions saying, at least in factual questions, administrative agencies should get some level of deference, meaning a reviewing court isn't going to look too closely. But what happened here is this was a legal question where the law was interpreted by the agency, and the court suggested, they said, was courts and everyone else must accept their reading of the law. And that is where the Chevron mischief started. Because while perhaps the court didn't appreciate the consequences at the time, they were certainly coming. And the best example of what happened as a result is in a decision from 2005 called National Cable and Telecom Association versus Brand X Internet Services. This was a familiar kind of case. This was a familiar kind of a problem. And this dealt with Title II of the Communications Act and the Federal Communications Commission's jurisdiction. It has jurisdiction over telecommunication services. What is that? According to the FCC at the time, this did not include internet broadband providers. So once again, we have an agency saying our power is more limited than other people might think. The problem for the FCC was that certain courts of appeals had said otherwise in interpreting the same provision and answering the same question. So we have Article III courts deciding a question of law, and then a federal agency, the FCC, coming back later and saying, actually, we are filling a gap, and we know better because the law is ambiguous. And so this teed up a question of what happens if Congress leaves a gap, who answers the question? The courts or the agencies? And in an opinion by Justice Thomas, which he later wrote that he regretted, the court ruled, as long as the prior judicial construction comes from a truly ambiguous statute, a gap that Congress left for us, the agency gets to decide the question, and despite prior decisions of a federal court. There is some question about whether that also extends to the Supreme Court. I don't think the court's ever going to get there, because now we have Loper Bright. But now this creates a conundrum, a constitutional conundrum, where we have a fight between two different branches of government. While this is going on, I do want to just highlight something about administrative process in general. Now, for people who are not familiar with the regulatory process, it is unbelievably complicated, drawn out, and some might say obnoxious. That's my assessment. But if you follow regulatory actions, there's usually an advanced notice of proposed rulemaking, a notice of proposed rulemaking that's somewhat revised, following comments. There's a solicitation of public comments. There are usually public meetings. And then there's finally a final rule that is published in the Federal Register. And traditionally, courts have said a rule becomes effective when it is published in a final form in the Federal Register, and that starts the clock if you want to challenge it. Now, the Administrative Procedure Act allows anyone, any affected party, to say, this agency rule is unlawful for some reason. And traditionally, the courts have said that the statute of limitations is 6 years from the date of publication. Normally, that doesn't cause any problems. A rule comes out, we all know about it, we have 6 years, we file a lawsuit. What happens, though, if you didn't know about the rule, if you did not participate in a challenge, maybe you didn't even exist at the time the rule was passed? As a matter of due process, the courts have said that if the rule is enforced against you, you always have a chance to defend yourself by saying that it is unlawful as applied to me. You do not, however, have an opportunity to ask a court to set it aside for the world at large. And that has some pretty big consequences. If you're a member of the regulatory space, you have to make a decision. and say, I think this rule is wrong. It's probably illegal. Do I violate it? We'll see if I have an enforcement, and we'll see if I win. Or do I make a business decision that maybe it's better to just go along with it? Most businesses, I think, follow the latter path, which I certainly would advise. However, if you're interested in following the former, please give me a call. We can talk later. So that's just kind of the background. But let's go and actually talk about the cases at the court this year. So Loper Bright, I think, was a very sort of typical Administrative Procedure Act case in a lot of ways. We have rules governing phishing, and it's really not important what the legal question is there. What is important is that the agency had succeeded in the proceedings below because of Chevron deference. Essentially, our construction isn't unreasonable or obviously wrong, therefore we win. And the court overruled Chevron, but it did so very narrowly. And I think this is part of what has been lost in a lot of the discussions. So as I suggested, there is a lurking constitutional problem. There is something fundamentally wrong or suspect about the constitutional design when we have an administrative agency, which is part of Article 1, the executive branch, or excuse me, which is part of the executive branch, which is an administrative agency that is taking on a lawmaking function. And the executive branch is writing a law, essentially, a regulation that is the force and effect of law, contrary to the wishes of Article 3 judiciary or the interpretation of the Article 3 judiciary. That creates a conflict. The court, I think, is sensitive to the conflict, and in concurring opinions, we know that Justices Thomas and Gorsuch would have gone farther, and they see the conflict and are very concerned about it. But as we've come to expect from Chief Justice Roberts, the majority was very measured and said, we are avoiding this at all costs. And instead, this was a statutory question. This dealt with the Administrative Procedure Act's review provision, which was never even mentioned by the Chevron court. And that seems to answer the question very simply. That part of the Administrative Review Act, the Administrative Procedure Act, says a reviewing court, quote, shall decide all relevant questions of law and determine the meaning or applicability of the terms of an agency action. This kind of suggests that a court should be interpreting law, not the agency, and the Supreme Court said, hey, what about this? We've been ignoring this for our entire history, but this kind of answers the question. What happens, though, is, so moving forward, the court said, we're just going to do what judges do. We're going to interpret the law. Agencies only get respect for their technical expertise. We will listen to them, of course, but lawmaking is for the court, or law interpretation is for the courts, lawmaking is for Congress. Agencies don't have any special power here. But the real question now is, how do you unring the bell? We've had 40 years of Chevron deference and a tremendous amount of rulemaking and litigation about all sorts of things. Justice Roberts' majority opinion talks about it really only in passing. He says, the time has come for us to leave Chevron behind, but by doing so, we do not call into question prior cases that relied on the Chevron framework. The holdings of those cases that specify agency actions are lawful, including the Clean Air Act holding of Chevron itself, are still subject to statutory stare decisis, despite our change in interpretive methodology. Now, when I first read that line, I think sort of understood what he was saying, and then I wrote in the margins of the document I was reading, lots of question marks. I certainly understand the sentiment, but I'm not sure how this plays out in practice. Now, for sure, decisions of the Supreme Court We respect them. They are entitled to stare decisis. And the court has said time and time again, including in Loper Bright itself, just because a case was decided wrongly is not enough to overturn it, at least from the Supreme Court. And so as far as that's concerned, I understand what the court is saying, and I think we can take the lesson that if a case has gone to the Supreme Court on an administrative regulation, applying Chevron framework, you're not going to get a redo. Not now, not from this court. But what about all of the cases that never went to the Supreme Court? What about all of the Chevron decisions from the courts of appeals, which there are many, and particularly from certain courts like the DC Circuit, which deals with an inordinate number of administrative law cases and was in many ways the most ardent adherent to Chevron. Are those up for grabs? Possibly. Now, the immediate reaction from the blogosphere is sort of what we would expect from Loper Bright, and depending on your political persuasion and depending on your view of agency power, you might have been very excited or very upset. Vox's Ian Millhiser, who is not necessarily known for his subtle takes on the court, wrote that, quote, the Supreme Court just made a massive power grab it will come to regret. He called the decision likely to be one of the most consequential modern day decisions, and he put his post under the tagline, welcome to hell. So, Blake Reed, a law professor in Colorado and tech blogger, warned of an impending Brand X net neutrality admin law demolition derby apocalypse. One can only hope, but he described Loper Bright like the proverbial dog chasing the car. The Supreme Court issued an opinion in Loper Bright versus Raimondo that finally catches up with the conservative wing's dream of dismantling the administrative state and bites down hard on the bumper by eliminating Chevron deference. I think to a large degree, some of this is very overwrought. But if we look at Corner Post versus Board of Governors, the other decision that I mentioned, I do think there is a good reason to question some of the chief's reassurances in Loper Bright. Now, that case dealt yet again with administrative regulation. We don't need to discuss the details other than to say the Federal Reserve is set under the Dodd-Frank Act with setting reasonable and proportional credit card processing fees. That is sort of a classic administrative law question. What the heck is reasonable or proportional? So the Federal Reserve passed a maximum rate. They passed that in 2011. Was challenged by the industry, DC Federal Circuit, or the DC Federal Court, after a trip to the DC Circuit and back, ultimately said the rule, their rate was reasonable. This was in 2014. The case died. The regulation hit the books. Our 6-year statute of limitations from the date of publication lapsed. Corner Post, however, was a convenience store that did not exist prior to 2018. So it didn't exist even when the DC courts were dealing with the regulation, much less when the regulation was issued. And they said, not unreasonably, how come we have to follow a rule that affects us that we weren't even around to challenge, and the only thing we can do is break the law and hope that we win a defense. So the court took up the issue, and they said, just as a matter of statutory interpretation, as a matter of the statute of limitations that applies to the Administrative Procedure Act, we look at when a claim accrues. A claim accrues when you're injured by something. So in Corner Post's very unique circumstance, they were only injured when they started operating, when they started having to pay the fee. So their 6-year statute of limitations started then. That's it. There was really no discussion of Loper Bright in that decision, other than Justice Jackson's dissent, when she noted that what about our statement in Loper Bright saying that we don't question all of these old Chevron precedents? And she said, she wrote, now every legal claim conceived of in the last 4 decades, possibly before, can be brought before courts, newly unleashed from the constraints of any such deference. For some reasons that we can get into in a little bit, I also think this is perhaps a little overwrought. I don't think every rule is up for debate, but I certainly see an opening. And I think that the combination of those two decisions is going to be monumental in the coming years. So what's next? And that's really what we're here to talk about today. Well, the short answer is lots and lots of remands. So what happened after the Loper Bright decision and also Corner Post is that the court dismissed a lot of petitions that were pending from a lot of different litigants on regulatory issues and sent them back down to lower courts to try again. So if you happen to be in the pipeline and don't have a final judgment before any of these decisions were decided, you now get to benefit from the new rules. And so the court remanded cases dealing with issues from the Social Security Administration, the Energy Regulatory Commission, the USDA, the National Labor Relations Board, and a significant number of immigration cases. But what happens now with the lower courts? And how do the agencies go forward from here? And I think even people in this space, even someone like me that spends a tremendous amount of time litigating these cases around the country, I think that there's a lot of open questions, and it remains to be seen. One thing that we have seen in the past that I expect to see more from the agencies is dealing with circuit splits in authority. And what I mean by that is not every case can possibly go to the Supreme Court, and not every regulatory case is going to be decided the same. And there are a number of instances, there always have been, where one circuit will come out differently from another, and you have 2 different sets of rules. Often the court will try to resolve it, but not always. What the agencies have done under the Brand X regime is they've said, we will settle this one way or the other, and now the courts have to listen to us. I think that is no longer the case. I think any close court watcher, despite the narrowness of the Loper Bright decision, I think there's a general consensus that Brand X cannot possibly be right, and it cannot continue to control and be the correct ruling. And I don't think courts are going to accept it anymore, even lower courts, because really the underpinnings of Brand X were Chevron deference. It was because the agency can do this and we must defer, they can control. And if that's no longer the case, then Brand X cannot possibly come out the same way. What I think will happen instead is something that we see a lot, oddly enough, in the immigration law context, which is where there are frequent circuit splits and there are frequent differences of opinion, and often the agency doesn't get deference for one reason or another. The agency instead applies multiple bodies of law depending geographically on where a person, a non-citizen, happens to be. And immigration practitioners can talk to you about it, and it's a little strange, but if you are in the Ninth Circuit as a non-citizen, you might have different rules than someone who is a non-citizen in the Fourth Circuit or some other part of the country. I think the agencies are going to be forced to do this. Whether that's a good or a bad thing, I don't know, and sometimes it may be both. But without a clear tiebreaker and without delegating it to the agency, there are going to be a lot of splits. Again, that's not all bad, and the court certainly always has the opportunity to settle the debate. One thing that has come up a lot in the discussion since Loper Bright has been, what about legislative fixes? Can we try to take deference back to the agencies? And my answer to that is maybe, but be careful. And I say that because in Loper Bright, the court very carefully avoided the lurking constitutional problem. And I say avoided it because if you read the briefing and certainly the arguments of the advocates, that was the main pitch. They were not going for a statutory decision on the Administrative Procedure Act's standard of review. They were looking for a constitutional statement from the court saying agencies cannot get this kind of deference. It is unconstitutional. Only the judiciary can interpret the law in a binding way. Ironically, the legislative efforts to restore agency deference, Chevron deference to agencies tease up the constitutional question that the majority tried to avoid. Because if we forcibly restore deference to the agencies in a way that the court cannot interpret around or avoid in other means, then that does create a conflict. And I think the court is also very clear that if push comes to shove and it has to face this issue, the agencies are probably not going to win. They're not going to be the ones who get to ultimately decide these questions. And as I suggested, the future of Brand X is very up in the air, but of course the Supreme Court hasn't told us that. So many of my friends are litigating this very issue right now. They're saying, well, Brand X can't possibly be right. We have to overturn these other decisions. But one of the lessons I think that I've drawn from this case and drawn from this pair of decisions is that the Supreme Court is certainly hostile to the state of affairs of the administrative state generally, but they're not willing to blow up the system. They're not willing to cause absolute chaos. And I think there's a fine line. But a lot of the arguments we've been seeing from advocates and opponents of the administrative state deal with issues about the separation of powers and the delegation of legislative authority and administrative adjudication and lots of very important questions. And time and again, the court has found ways to avoid the worst or the most destructive implications because the court is not ready to change everything suddenly. But what they are ready to do is to cut back on the margins and reduce the power. And I think if I take that as a signal, and this is my job to some extent, is to try to guess where I think the court is going to go and see what opportunities we have, I think what we can do is we can challenge old rules, challenge old decisions, and tee up the debates in the lower courts and take best advantage of the situation with the idea that if things get truly out of hand, the court might intervene. But the court probably is willing to let this play out a little bit. I think the refs are kind of taking a step back at this point. Now, I know we're going to have a conversation, and there's a number of other questions that we can discuss, but I see this cautiously as a revolutionary pair of decisions that allows a lot of new work, but it certainly remains to be seen whether some of these more dire predictions will come true.
Well, thank you very much for those very insightful comments. Very nuanced comments. I was wondering if you could tell us a bit about what's happened just in the past couple of months since the Loper and the Corner Post decision, and the case that I have probably followed the most closely is the appeal of the latest round of network neutrality at the Sixth Circuit, where the Sixth Circuit actually granted a stay of the rule, which I don't think they would have done pre-Loper, but they sort of, I think in the absence of in the absence of Chevron, I think the Sixth Circuit is sort of saying, FCC, you've got a very difficult time proving why you changed the rules like this. Are we seeing this in other courts as well, or how's this playing out?
I think we are, but I also think it's very easy to sort of point to Loper Bright and say, this changed everything. And that is in no way accurate if you've been following these issues for any length of time. And I see this is really the ebb and flow of separation of powers in the sense of who do we want making the decisions. And I think the Supreme Court sets the tone for the lower courts, typically. And I think after Chevron was decided in 1984, we sort of saw the rise of administrative authority. And I think the high watermark of that was Brand X. And it was the sense that the agencies, we want to be hands-off as a court. The agencies, unless they're doing something really bad, we don't step in. That started backing away long before Loper Bright. And if you've watched the court over the last few years, you've probably heard things like the major questions doctrine, which, and this is something that the Chief discussed in his Loper Bright decision, is that the Supreme Court had not applied Chevron deference since 2016. And there were so many carve-outs that Chevron was really the exception in litigation. And so from that kind of very high point, the end of Chevron is maybe not that big of a deal, or it didn't change that much, but it's also like the last great tool of the agencies. They don't have it anymore. It always seemed like when you were litigating against an agency, they could, and their back's against the wall, they say Chevron and it might work. And they might get out of it, they might win, you might lose the case. That's not the case anymore. And so it's really they're running out of options, I think.
Yeah. Sorry to focus on network neutrality, but I'm thinking of because the FCC would go back and forth depending on which administration was in power, and the DC Circuit would apply Chevron, but neither of the most recent cases actually made it to the Supreme Court, and so this is the example where...
Right. And so I think part of it too is there's a real difference in the kind of gap-filling powers we're talking about. And I think part of the reason this comes up in the communications context so much, we also see it in certain situations like with the securities context where we have very, very, very broad statutes where instead of delegating kind of narrow questions about how many particulates is too many particulates, it's do things that are reasonable for telecommunications. It's protect investors.
Yeah.
And when you have that kind of a delegation coupled with Chevron deference, you're sort of untouchable. And so now the agencies are really stuck in a position where they have to try to reformulate some kind of principled limitation. Because I think really the end of Chevron deference is really a question about delegation, about too broad powers for the agency. And now really they have to struggle and come up with some kind of grounded, reasonable way to limit their own powers. So yes, we've seen some action from the other courts. I think there's some interesting fights now between the DC Circuit, which has been a huge fan of Chevron for a very long time, and other circuits, and even in the last few years. I mean, there's a pronounced difference between something like the Fifth or the Sixth Circuit and the DC Circuit on administrative law issues. That's not going to go away.
How does this affect agencies that are not I'll say exclusively under the APA, and one that you're very familiar with, like the Federal Trade Commission, which in the past few years has started to actually write regulations, which it really rarely did before. How does Loper affect them?
Well, it is sort of twofold. I think the Federal Trade Commission is a great example because they have a very long, troubled history with trying to write substantive regulations, and for a long time, they haven't been doing so after there was a huge scandal and congressional action. But they started again. And there's a lot of litigation right now dealing with a Federal Trade Commission rule governing non-compete agreements, which you may be aware, the commission, in a very contentious 3-2 vote, decided that every non-compete agreement in the country is unlawful, per se, even existing ones, notwithstanding the fact that 46 other states have said they are permissible under state law in various contexts. So that created a big issue for a lot of people, and there's been a lot of litigation. And so far we've had 2 cases where judges have said, we do not think the FTC has any regulatory authority substantively in this kind of context. But if they do, we certainly are not going to give them any deference to their position, and they have to prove, just like any other litigant, that their actions fall within the statute. And so I think just as an overlay, even when it doesn't come up directly, I think, again, it is really captures the sense and the sentiment that there are constitutional problems that we have to be aware of. And if it's a close call, courts are much more likely to say the agency loses because we don't want to threaten the constitutional questions.
Do you anticipate any type of, or let me rephrase that. How do you anticipate, or what do you anticipate agencies will do in response?
I think part of what the agencies will have to do, at least in the short term, is, as I suggested, they'll probably have to come up with differing bodies of law that they'll apply regionally, which again is not something that is completely unheard of. It's just not that well known, and it can cause some problems when you have litigants who are in lots of different places. That's one possible solution. I know the agencies are trying very hard. They're on the Hill a lot, trying to come up with some sort of legislative solution. As I said, I think there are constitutional problems with that. And also, I do think the agencies are trying to just do good old-fashioned lobbying. And this is the one really positive outcome that I see, in that there is a sense that if the court is not going to allow agencies as much leeway as they've had, then Congress they better start writing some details, and they need to start actually deciding these questions themselves. That is the most positive outcome, in my view, because that's what we wanted all along, as we wanted our elected representatives to be deciding monumental issues of law, and then face the voters if voters don't like them, or if they do like them. So that's kind of the immediate thing that I see. And then some, I think, are sticking their head in the sand. So I say that, I'll just give you a ready example. There's the USDA has a proposed rule right now that's open for comment, and I'll be filing a comment in the next few days. But it claims to clarify the scope of the Packers and Stockyards Act on a pretty sort of technical question about unfair competition and interstate commerce and sort of traditional questions. But what creates a problem is that, as the agency has acknowledged, the different courts of appeals have all sort of rejected the agency's proposal as a matter of statutory interpretation. And we have at least 6 circuit courts of appeals saying the agency's view on this is wrong as a matter of law, it is inconsistent with the statute. And then we have an agency saying we are clarifying the statute to have a substantive rule that encompasses our longstanding position that has been rejected by 6 courts of appeals. I don't think there's any rational way to read Loper Bright or any of the recent decisions and say that that is correct. But I think the agency is sort of daring us to make them. So I guarantee there's going to be litigation if they go forward with that, and we'll see what happens. But you know, in something as big as the government, some of the agencies will try and some of them won't.
I have lots more questions, but let me open it up to the audience here for questions. Yes. Yes.
Okay, I've been writing on this off and on for a bit, but
Oh, and please identify yourself.
J.P. Hogan. On Chevron, a lot of it's abusing Congress's power of the purse, and in some ways, now it has to happen that we take it apart because the administration is trying to have almost tyrannies, authoritarian tyrannies, whereas our Constitution, originalism is there's no presumed right that a federal expert is more an expert than a local expert. We're actually, Washington's supposed to be where we come and deliberate on the issues in real time. So I don't want to get too across the spectrum, but it goes into now what would be an infringement of one's religion if the federal government is bypassing Congress's power of the purse so much, trying to dictate, especially with climate change. You then run into Logan Act and collusion problems that foreign administrators are now being globe-trotting, trying to affect change and force that change on Americans. So just want to open up the discussion along those lines.
Yeah, well, I think another sort of piece of litigation that has been directly affected by Loper Bright is the challenge to the SEC's greenhouse gas disclosure rule, which raises a lot of the issues that you're talking about. And if you're not familiar with that, last year the Securities and Exchange Commission issued a rule saying essentially for most publicly traded companies, they have to do public yearly disclosures of their estimated impacts on the environment. As a lot of industry pointed out, that's really, really hard to do, and a lot of the disclosures that they were required to do are really, in some ways, impossible to figure out, like downstream impacts on CO2 and the impacts of possible weather events on your business line. And the idea from the agency is, well, an investor needs to know what the company does and how vulnerable they are to climate change. And as the industry said, this is impossible. What are we supposed to do?
Climate change seems such an international issue. Should have almost had treaty status of needing 2/3.
Yes, and also what the heck is the Securities and Exchange Commission doing, telling us about the environment? So that was the fight, and that case is being litigated right now, and it has also been stayed, and I think the Commission's reliance on Chevron throughout the rulemaking process is in many ways going to be their undoing, because they sort of made a bet and they said, we're justified in part because of our power under Chevron, and now that statement is not sitting well with the court, and I think they're regretting that. So yeah, we see a lot of these kind of really egregious overreaches. There's not even a passable defense now.
In the back. And please identify yourself.
Yes, my name is Roger Cochetti, and I'm an editorial contributor on technology policy for the Hill newspaper. And as a non-lawyer, you'll bear with me, I have some non-legalistic questions, one of which is, if I were a fundraiser for a member of Congress, I would pop the cork. This is fabulous, because now we can claim that every regulation has to be done in our subcommittee. Every subcommittee now needs a staff of 100 people, and is not the political outcome of this over a period of years to be subcommittees of congressional committees turn into effectively regulatory agencies with the expertise, and every other year we pass a new statute updating the previous statute as circumstances or technology change. Second question is, just listening to what you've described, it seems to me that as a matter of politics, the federal agencies have the DC Circuit as their shield. So the DC Circuit will say everything you did is fine, everything you did is fine. So I don't know, is it possible that the Supreme Court can then retry the same facts that the DC Circuit has already said, that's fine, that's fine, that's fine, that's fine. So and just one other quick question. I'm not clear, does Corner Post make all statutes of limitation, federal, county, state, municipal, on any subject unconstitutional, or is it sort of, I'm confused about, because it sounds like you're saying that the concept of a statute of limitation, which says the person before the statute expires has more rights than the person the day after. So it sounds like any statute of limitation is gone now. I don't know.
So I'll take those in reverse order. Okay. So let me clarify a little bit about what Corner Post held, and that is just on this very narrow statute, on the specific statute of limitations that applies to the Administrative Procedure Act procedurally. And all the court said was a claim accrues, the clock starts running whenever someone is injured. We will let it up to the lower courts to decide when that is exactly. And we think Corner Post, probably their injury started when they operated, when they began business, so they get a special kind of an extension. They can challenge this rule for everybody. Now, this has, in the administrative law context, it's a little bit unique though, because we essentially have rules that come out, they apply to everybody, and then you have a limited time anywhere in the country to challenge it. Corner Post opens that up, I think, but it's only for federal administrative regulations. So there is some limit there. Now, as far as your statement about the congressional committees, and exactly, that is that's the outcome I think is appropriate and that should happen. And I think, we've seen the agencies rise and they have this very complicated bureaucracy, and there's no reason that cannot be supervised or overseen by Congress. But what is important, in my view, is the question of accountability, because when an agency is being run by a political appointee and they change every administration and they sort of seesaw back and forth, that is a problem, and that is a problem constitutionally. And if that is being overseen by Congress, then the voters, I think, get back the control that they are required to have. Now, what about the DC Circuit? So, no question that I think the DC Circuit for a very long time has been pro-agency, or they love Chevron deference. That certainly many of the judges there do. I read the retroactive consequences of Loper Bright to say that many of those cases are fair game. And I expect a lot of litigation in the other circuits to revisit some of these questions, some of these issues, some of these old rules that the DC Circuit might have said, yeah, that's fine. There's going to be a lot of litigation about that. And I think Corner Post is the classic example. That was a case where the challengers lost in the District of Columbia. The clock was over. Everybody just sort of threw their hands in the air. Corner Post was originally brought in the 8th Circuit. They are still litigating now. I would not be surprised if the 8th Circuit invalidated that rule. And that could potentially have some destabilizing consequences. We'll see. And I think the court, if it's a big rule like that, they may have to revisit it. There may be a Corner Post 2. And so that is, I think, why I think the Chief's suggestion is maybe a little, I think it's a little bigger than he's making it out. So I think that's something we will definitely see in the coming years.
Yes, over here.
Good morning, Jeremy Bongiovanni from the Swiss Embassy. I would have 3 questions, 2 a bit longer and one which is shorter. The first one on Corner Post. The first time I read the decision, I was wondering if they didn't make it very easy for any economic actor, or any actor, but let's say any economic actor, especially like a big actor, who's active on the market, has been active on the market for a long time, and who has the problem of a certain statute, to say, okay, we'll use another entity, or create a new one, or use I don't know, I could use just if I'm let's say I'm Walmart and I'm not happy with the new statute, but I'm the statute of limitation is already expired for me. I could say, okay, this new shop, this new I don't know, a shop on the street who's been created 6 months ago could have an action and contest the statutes. Is that a weakness of the decision, or is there something against that? I don't know if I should ask my 3 questions.
Sure.
The other 2 ones are regard Loper Bright. First and short, I'm sorry if I didn't get that, but at a certain point in your remarks, I felt you were going to the fact that it was in some sort a constitutional decision, but you started saying it was a more statutory. And I think also in the decision, they mentioned Marbury versus Madison. So there's maybe, for me, it was like 20% constitutional, 80% statutory, but I don't know what was your take on that. That's the shortest question. And then my last question on Loper Bright too. There's something I don't understand. Maybe that's something specular for American law, but my understanding would be if there is a decision on a lower court, after a certain amount of time, you cannot contest it anymore. So I would say, let's say a decision that has been decided 10 years ago based on Chevron doctrine, I would say for that decision, I don't understand why the Loper Bright decision would make any difference. I get it for a decision that was made, let's say, 2 weeks ago, and they would say, oh, now we have a new Supreme Court stare decisis and a new line of the Supreme Court, and this makes a difference. But otherwise, I'm not sure I understand that. I hope that's clear, but this time dimension is not clear for me. Thank you.
So these are 3 very interesting questions, and I will try to give you an answer. I don't know that there is an answer to all of these, and I will try to take them in reverse order. So just starting with, and now the Corner Post case. That certainly is a weakness, and I think that is something that Justice Jackson highlighted at oral argument. There's really nothing to stop a big company from creating a new entity just to challenge it. Frankly, I don't see a problem with that, and I say that because this has been an aspect of American law forever. And as somebody whose job it is to recruit plaintiffs and people to challenge cases, I personally don't see anything wrong with it. And I think it is an important aspect of American court system. I think Homer Plessy from Plessy versus Ferguson was recruited to make that challenge. And I think that is an important aspect of finding people who are affected and let's try to change the law. There are certain circumstances where if it's fraudulent, or if there's certain, there is room for a lower court particularly, to say, there is something wrong with this litigant, I don't think they have a valid claim. As far as your classification or my classification of Loper Bright, it claims it is merely a statutory question. I think probably it's 60-40, as in, if we don't answer it this way, there's a really complicated, scary constitutional question we have to decide. So we're going to kind of lean extra hard to avoid it, even if we don't say that out loud. That's me sort of reading the tea leaves. But I think there's a real sense from the Roberts Court of avoiding constitutional conundrum, some sort of real problem, even when they're not saying it. And they'll sort of decide it, and it will certainly weigh on the decision. And as far as stare decisis and how these kinds of old decisions affect us, this again is about administrative law, and in the sense that these decisions are on the books, they are valid. A circuit decision is valid in the geographic circuit that you're in, it's binding, you're stuck with it. But as long as you're not the original litigant, if it was Walmart versus the FTC 20 years ago, Walmart's out of luck. But anybody else, I think you have a valid claim, good for you, and let's try to create a new entity and let's go after it. I mean, that's my view. And so how that plays out, we'll see.
May I ask something? What did the Roberts or the court meant when they say we won't go back on these decisions then? Because I agree, I would say, yeah, then you could have two other parties and they could fight under the new jurisprudence.
I think what the court is saying is that there's a real difference between our precedent and everybody else's precedent. Supreme Court cases are super. And it takes a whole lot more than just we were wrong to go back on them. Circuit courts, not so much. And the Supreme Court, I think, has sort of variable respect for lower court decisions. And sometimes in the past we've heard them say their stare decisis is the same for them. I think in practice it's not something we see. So my recommendation, my prediction is any case the Supreme Court has decided on Chevron, it's going to be a very long time before those go up again. But the circuit courts, I think there's going to be a lot of action in the coming years.
Any other questions? If not, please join me in thanking Caleb Kruckenberg.